All right, good morning, everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, we are going to address each person. I've read the probable cause affidavits, and we will make a determination as to probable cause, and then we will talk about release conditions. Today is not your trial date, so please keep in mind that everything that you say on the record today is being recorded and can be used against you at a later time. If you are represented by counsel, either from the Public Defender's Office or private counsel, you may want to speak with your attorneys before speaking on the record. In the courtroom, I do have with me an attorney from the Public Defender's Office, Mr. Brian Reedy. Over at the main jail, we have the attorney, Hector Romero. And if you have private counsel, they come to the courtroom and are able to speak on your behalf. Also in the courtroom, I have an attorney from the State Attorney's Office, Mr. Eric Linder, as well as we have representatives from pretrial supervision and confinement status. They are here to help to facilitate providing information during the proceedings this morning. I also have the clerk of court who maintains the records. So please note that if you need to talk about your case, you can certainly talk, but make sure that you check with your attorney before saying anything. If you are represented by private counsel and the attorney's not here, you can let me know and we will see how we can facilitate that process. But please don't tell us that you have private counsel, have us make a phone call only to be told that you are not being represented by that attorney. Just because an attorney represented you a year ago or 2 months ago does not necessarily mean that they're representing you on this current arrest. So unless you or your family have retained counsel for this arrest, they may not be representing you. Okay, we will begin this morning. The jail has asked me to call some cases out of turn. And so at this time, I will call Scott Peterson.
Good morning, Your Honor. Joseph Jerusalem on behalf of Mr. Peterson, together with Daniel Later from my office.
Good morning, David Sobel on behalf of Scott Peterson.
Good morning.
And Your Honor, I do have a written motion to reduce bond and to modify the conditions of pretrial release if this court be willing to entertain it at this time.
No, I'm not going to entertain any motions this morning. This is First Appearance Court. I am going to make the probable cause finding. There are 11 counts. A circuit court judge has reviewed the affidavit to arrest and have made a determination as well as imposed certain bonds and bond release conditions. And this morning, I am going to stand by those conditions that are in the report.
And I understand, Judge. Just for purpose of the record, we would like to challenge the probable cause determination.
Okay.
Because we do not believe that my client, in respects to the statutory violation under 827.03, that he meets the statutory definition of caregiver. That is especially so given the exclusion under section 39.01 subsection 54 expressly carves out law enforcement officers acting in their capacity as a law enforcement officer. So as a result, we don't believe that there is probable cause in respect to those felony counts.
And Your Honor, if I could briefly, Eric Linder on behalf of the state, if I could briefly provide a response just in case a writ should be filed. Your Honor, under Florida Rule of Criminal Procedure 3.133A1, and that has to deal with non-adversarial probable cause determinations, the rule clearly states that such a hearing or determination is not necessary when an arrest warrant, when that determination has been previously made by a judge and an arrest warrant issued for the specific offense for which the defendant is charged, as is the case in this matter.
Okay, so based on the affidavit to arrest that was signed by Judge Siegel, and also the bonds that the court does find probable cause, and also the bonds that were imposed along with special conditions, those special conditions will remain in place, and a total bond of $102,000. Okay,
Thank you, Your Honor.
thank you.
Judge, if one final thing.
Sure.
One of the special conditions of bond is that my client turn in his passport. My client resides in North Carolina, and as a result, his passport is in North Carolina. We would ask that the court modify that condition to allow 72 hours, so effectively my client can go back home, FedEx me his passport, and I can personally surrender it to the clerk of court.
Is there no one that could send the client's passport in from North Carolina, as opposed to him going to get it and to send it in? Normally, under normal conditions, the passport has to be surrendered prior to release.
I understand, Judge, but, to answer your first question, I believe there is a person that might be able to.
Yes.
But given that my client, that this person would have to travel from Florida back up to North Carolina, and in order to do this, I'm anticipating that this is going to take at least a couple days, and that my client would unnecessarily remain in custody until that takes place. So I just asked for a couple days for this to occur.
The state would request that the court take no action modifying this condition. Your Honor has already ordered that the collateral requirement remain in place, which means he's going to have to go in front of his assigned judge to sign off and find that the collateral condition has been satisfied before he could be released. This matter should be taken up by his assigned judge to determine if the inconvenience that counsel is determining outweighs the need to ensure that his passport is surrendered prior to his release.
All right, I'm going to deny that request at this time as well. Okay,
So, Your Honor.
thank you.
Thank you, Judge.
Thank you.
Okay, Jolanda Bowles.
Have a good one.
Okay, Jolanda Bowles.
Your Honor, she's at North Broward. She's on the phone with Mr. Reedy right now.
And Judge, this is the main jail. We have the juvenile here. We're asking to call the juvenile so the juvenile can leave the adult facility. It's on page 15. Anton Green.
I said, hold on until I get everybody in. What? All right.
Okay, Anton Green, and just for the record, Mr. Green has been direct filed as an adult, and so he's before the court this morning. He's charged with 1 count of robbery with a firearm. The court finds probable cause. I'll hear from the parties as to bond.
Your Honor,
Judge, at this, go ahead, State.
thank you. Your Honor, the state would be seeking a finding of proof evident or presumption great for first appearance purposes only, relying upon the probable cause affidavit and seeking a no bond hold in this matter.
And Judge, that was explained to Mr. Green, so we'd ask for the first available court date before it's assigned, Judge, so we could put together an Arthur hearing package.
All right, so at this time, the court finds probable cause, makes a preliminary finding of proof evident presumption great. Mr. Green will be held no bond. This is without prejudice for him to have a bond hearing before his division judge based on State v. Arthur. Good luck, sir. Wow.
Judge, I'm sorry, we're asking that one more person be called out of turn here in the jail. That's on page 20 of your docket, Marvin Arriga.
Okay, Marvin Arriaga is before the court this morning for one count of grand theft, and count two is possession of drug paraphernalia. The court finds probable cause.
Judge, at this time in regards to bond, the bond on count one is set at $1,000. And speaking with Mr. Arriga, we are going to ask that the court ROR him on count one. Unfortunately, at this time, he has no money, no access to money in order to post a monetary bond.
Michelle.
The problem we have as well is he's a New Yorker. He's only here on vacation. He does not reside here in the state of Florida. He indicated he did have a valid address in New York. He indicated he would make any and all court dates in regards to his Florida case. But in order to leave the facility, he is going to need an ROR.
Your Honor, from what I can tell, the arrestee has, from what I can tell, two pending criminal matters out of New York. I see an arrest November 19th of 2018 under the name Vanessa Lopez, assault in the second degree, intent to cause physical injury with a weapon or instrument. Another arrest September 22nd of 2018 under the name Marvin Arriaga, criminal possession, controlled substance, and theft. There's multiple priors out of New York. I see priors out of Texas, New Hampshire. There's been priors out of Broward going back to 2010.
Okay, at this time, Mr. Arriaga's bond is $1,000. Shanteria Barnes.
North Broward, Your Honor.
Ms. Barnes, you're before the court this morning for two additional charges. Leaving the scene of a crash involving damage to property, count four is operating without a valid driver's license, and the court finds probable cause. I know that Ms. Barnes was here yesterday. Is that correct? Was it yesterday?
Yes, Your
Yes.
Honor, I believe so. The bond on that was a new traffic offense.
Okay.
Yeah, her mother bonded her out on the no valid license and failing, I guess she didn't need a bond on the failing to register a motor vehicle. From speaking with Ms. Barnes, I don't believe her mother's gonna be able to come up with any additional money for the bond on these two charges. I'm gonna be asking the court for pretrial release. She has been a resident of South Florida all of her life. She lives with her mother. Unfortunately, she has a disability that prevents her from working, so she has not been able to save up any money to enable her to post a monetary bond at this time. She has had contact with the criminal justice system, but from what Ms. Barnes tells me, that was somewhat remote in time. So I'd ask the court to consider pretrial release for Ms. Barnes.
Under the state would oppose. My concern is it's the nature of the offense combined with that she didn't appear in court on it. It was only brought back into custody when she was again driving without a valid driver's license.
And how much bond did she already post?
$25.
All right, so we'll leave the bonds in place, $2,000.
All right, I'll call your mom for you, Ms. Barnes.
All right,
So I gotta pay for the bond?
The bond is $2,000, so I'll call your mom.
Lataja Davis,
Good, 172.
all right, Ms. Davis is before the court this morning, burglary, unoccupied dwelling unarmed. Count 2 is petty theft, and the court finds probable cause.
Do you want to go by yourself? Do you have any children?
When was Ms. Davis placed on pretrial?
Do you work? What'd you say, something? Go down 400. You get assistance from the building?
Your Honor, well, that's being looked up, just also for the court's consideration. It's mentioned in the new PC, and I did confirm, the burglary that Ms. Davis is out on was also close in proximity to this home. The other burglary occurred at 490 Northwest 46th Avenue in Plantation. I would also note that in 2012, Ms. Davis was convicted of burglary of a dwelling and grand theft, violated probation, and was sentenced to 28.5 months state prison.
Ms. Davis was released to pretrial supervision in this case back in December 20th, 2018.
And what was the charge? I'm sorry, there's a lot of,
Burglary, unoccupied dwelling, grand theft in the third degree.
okay.
Just to advise the court, Your Honor, she received a $5,000 bond and a GPS monitor
$5,000 bond and a GPS monitor.
on that case, yes, ma'am.
And that's on the case that so this
the pending
pretrial
burglary
matter,
dwelling.
she also posted a $5,000 bond?
Yes, ma'am.
Judge, in speaking with Ms. Davis, according to Ms. Davis, she's currently not on any form of supervision as far as probation is concerned. She has been a Broward resident her entire life. Unfortunately, at this time, she has no access to money in a checking nor savings account, and she's also indicated she's never missed court her entire life. Due to the fact she just had to post money for a previous open case, we are going to ask the court to set count 1 at $2,500 to enable her to afford that bond.
Well, on case number 18-015-562 CFNA, I am going to revoke the pretrial supervision, and she's going to be held no bond on that case.
Thank you, Your Honor.
Until further order of her division judge. And as to this new arrest, I am going to impose a $2,500 bond on count 1, and she has $750 on count 2. Bianca Martinez. Okay. Su Yang Yi. All right, ma'am, you are before the court this morning for 1 count of grand theft. And the court finds probable cause. Here is the bond.
Judge, as far as bond is concerned, in speaking with Ms. Yee, we can keep the bond that's in place. Last night she called Around the Clock Bonds Company, so they're in the process of bonding her out as we speak, and I'll call this afternoon just to confirm that.
Okay,
I'm
all
not asking for any modifications,
right,
Judge.
so she is a $1,000 bond.
I'll be getting in here today, okay? I'll make sure we call them.
LaQuesta Allen.
Judge, we are asking, just let the court know, Ms. Bowles from page 1 is back and available when you're ready.
Okay, so let's do Miss Allen and then we'll do Miss Bowles. LaQuesta Allen.
Full run, Your Honor. Yes.
All right, Ms. Allen is before the court this morning for aggravated assault with a deadly weapon without intent to kill.
James Miller.
All right, the court finds probable cause.
Your Honor, the state would be requesting a $10,000 bond, no victim contact, no possession of any firearms. My concern being the fact that this allegedly involved a firearm. I'm not showing any local priors. Does pretrial have any notes as far as any priors outside of Broward County, please? I can't even. I'm sorry.
All right, I believe at the main jail, if you could turn the mics off.
Thank you, Judge. I'm sorry, Michelle? Okay. Nothing further, Judge.
Okay.
Judge, in light of the fact that she doesn't seem to have any contact with any prior contact with the criminal justice system, I'd ask the court to consider pretrial release for Ms. Allen. Of course, we would agree to no contact and no weapons.
All right, I'm going to place Ms. Allen on pretrial with a level 2 GPS, no contact with the victim, and no firearms or weapons. Do you understand that, ma'am?
Yes, ma'am.
Okay. All right, Stephanie Stern.
North Broward.
Oh, okay.
She's the med reset, Your Honor.
All right.
You're gonna be next.
And then Jolanda Bowles. Ms. Stern is on medical reset. This? Jolanda Bowles. Ms. Bowles is before the court. Count 1 is a touch or strike battery. Count 2 is possession of cannabis 20 grams or less. And count 3 is introducing contraband into the detention facility. And the court finds probable cause. And I'll hear from the parties as to bond.
Thank you, Judge. Judge, we are going to ask that you take a chance with Ms. Bowles, and you ROR her on all counts. She is a single mom raising 2 children, ages 8 and 7. She's currently not on probation. She does have a full-time job. She works for Chewy.com. She's been a Broward resident her entire life. She actually went to Coconut Creek High School. According to Ms. Bowles, as an adult, she's never been arrested for a felony before. This is her first one. So as a result, due to her not having much money saved, no money in the account, all the money she has goes to provide for her children. We are going to ask that you ROR her on the remaining counts.
Your Honor, moment. I only see traffic priors. There was an arrest for a failure to appear last year. Based on the level of violence, the state would be requesting a $1,500 bond on count 1, no victim contact.
And Judge, I was made aware that this is looks like maybe a domestic dispute. It wasn't a stranger. It was an argument between her and her significant other.
All right, I'm going to place Ms. Bowles on pretrial supervision, no victim contact, and I'm also going to add random drug testing.
So I can educate Ms. Bowles, what level of pretrial, would that be standard?
Yes.
Okay.
Okay, ma'am, the deputy or the attorney will give you the information for pretrial supervision. You need to report to the pretrial within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. And also as a condition of being on pretrial, no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. That condition is imposed, as well as you will also be subjected to random drug testing. Do you understand that, ma'am? I have to hear you speak. Do you understand?
Yes, Judge.
All right, good luck.
Thank you.
All right, Precious Jackson,
North Broward, Your Honor.
okay? All right, Ms. Jackson is before the court this morning for one count of arson of a dwelling where people were present. The court finds probable cause, and I'll hear from the parties as to bond.
Well, I can tell you, Your Honor, from my conversation with Ms. Jackson, she is not going to be able to post anything close to the bond that's currently listed at $150,000. She might be able to make a more reasonable bond. I'd ask the court for a $10,000 bond. I believe that that's something that she and her family could afford.
Your Honor, frankly, I don't know that Judge Williams's bond is inappropriate considering the allegations in this case. She, with premeditation, went to her ex's home. She went into the home without permission. She set a room on fire. There was one resident in the home that could have been seriously injured or killed. She essentially mocked one of the victims after the fact, texting him, "You should go back to your home." Basically admitting, there's a fire upstairs. Wait, one moment. She stated to one person in the home, "There's a fire upstairs, you need to put it out," and I set the bedroom on fire. And then she sent a call to the ex, "You better go check on your house." I do note she's been arrested previously in '09 for aggravated assault, a deadly weapon. That was dropped. And for aggravated battery in '04, that was dropped. And I note those priors because it does appear that there's a domestic element to this matter, seeing that it's an ex, Your Honor. Obviously, I'd be asking for no victim contact with any of the residents of that home, no return, and pretrial release with a GPS monitor.
Well, we would have no objection to the GPS monitor, no contact with the victim, no return to that residence. Our main concern is the monetary aspect of this bond, which is well beyond Ms. Jackson's means to post. So I believe she could get a $10,000 bond together, but a $150,000 bond she's just not going to be able to do, Judge.
Well, these allegations are pretty serious. Setting fire in a home when someone else was in the home, and the damages that occurred as a result of this fire. I'm gonna leave the bond at $150,000. No victim contact. If she posts her bond, she'll be on a level 2 GPS, and no return to this address. All right, Frederick Warren. Okay, Mr. Warren is before the court this morning. Count 1 is touch or strike battery. Count 2 is burglar with assault or battery. And the court finds probable cause.
Thank you, Judge. In regards to count 2, Judge, according to Mr. Warren, this is a girlfriend's house. They actually live together. Mr. Warren's resided in Broward County his entire life. Since 2010, he's maintained the same job working for the Publix warehouse. And according to Mr. Warren, he's never missed a court hearing previously. I did speak to him about count 2. I don't have the probable cause affidavit in front of me, so I don't know to the extent of the facts, but we would be asking if the court would set a reasonable bond on count 2 for $5,000. And on count 1, since it's a misdemeanor, leave it at 0.
Your Honor, the state is going to be seeking a no bond hold on count 2 upon a finding of proof evident or presumption great for first appearance purposes only. Your Honor, first, with respect to the allegation that they reside together, I would direct the court's attention to Mr. Warren's booking sheet, which lists a permanent address of 25 Southwest 8th Avenue in Dania Beach, 41 months of residence. I would also direct the court's attention then to the short arrest information form, which indicates the place, one moment, Your Honor, also shows his address, showing the same address. In the arrest warrant affidavit, Your Honor, it is clear the victim advised Mr. Warren he did not have permission to come to the residence. Once he entered unlawfully without permission, an argument ensued because he did not have permission to enter the residence. The allegations is he struck the victim. This was witnessed by her juvenile son. And the officer also documents and notes the injuries that the victim suffered to her face, scratches on her right arm, right leg, neck, and a laceration on her bottom lip.
And Judge, Mr. Warren wanted the court to know 2 things. One, that the child is Mr. Warren's child. And 2, he indicated the reason he's not on that address, the same address as the listed victim, is because she's in housing and is not allowed to have somebody else on that specific application for the house. So that's why he used his parents' address.
All right, the court finds probable cause. As to count 1, the bond is $5,000. On count 2, I'm going to make a preliminary finding of proof evident presumption great. This is without prejudice for Mr. Warren to have a bond hearing based on state v. author. Mr. Warren will be held no bond until further order of the court. No victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Okay?
Thank you, Judge. We can just request the quickest possible date before his assigned judge, please. Thank you.
If you want.
Then Tito Robinson. Mr. Robinson is before the court for 1 count of aggravated battery, where the defendant knew or should have known that the victim was pregnant. The court finds probable cause.
One moment, Judge.
That's why we're waiting on the state. In speaking with Mr. Robinson, the aggravated battery is an allegation with the girlfriend. They actually lived together for the past 7 months. Mr. Robinson has maintained the same job for 13 years. He works for a travel agency selling vacations. He's been in Broward since 2007. Prior to that, he resided in Dade County since 1989. He's not on any provision. He's indicated he's never missed court, and he's not been in trouble in well over a decade, according to Mr. Robinson. As a result, we're going to ask the court to set a financial bond at $2,500. That is something Mr. Robinson would be able to manage to get out.
Your Honor, I would note the state's going to be requesting a $10,000 bond and no victim contact. I would note as far as the claim that he's never missed court, he was arrested in Broward in 2014 on a failure to appear capious on a possession of controlled substance. In 2007, out of Dade County, he was, let me see what happened with that case. Convicted of felony battery. I would also note that in the past, 2 separate women have sought and obtained non-expiring injunctions, orders of protection against Mr. Robinson.
right, this time I'm going to impose a $10,000 bond, no victim contact, until further order of the court.
And Judge, in regards to Mr. Robinson, if we could also ask for the first available date before his assigned judge, thank you.
I know Shirley, are those requests, the PD's making requests for first available date in his division? Is that something?
It doesn't normally, it just goes in a normal,
I mean, I don't even know the first available date for what.
Right, because I can't,
it goes first available date if they got picked up on a warrant,
I-
new charges.
I don't control another judge's docket or anything like that, so.
And I don't even know what the hearing would be for.
All right, okay, and Mr. Pierce is not here with us? I mean, after the second time, it's, okay. All right,
Morning, Judge.
Mr. McLaurin, good morning.
So what the,
They keep resetting, we keep resetting.
Mr. McLaurin.
All right, Mr. McLaurin, why are you standing at the podium?
I'm sorry, Judge, I didn't hear you.
I was saying, why are you standing at the podium? There are other people before you.
Oh, no, that's not a problem, Judge. I'll run up to your courtroom.
No, that's it. Are you ready to address it? Because Mr. Plant's got like 2 pages here, so,
Yes, I'm ready.
all right.
I'm sorry?
All right, Willie Williams, that's Mr. McLaurin's case.
Mr. Williams. Come on.
Jonathan.
Mr. Plant, you have time to wait or time to come back? Because sometimes we just want to clear out some of the persons. And then when you come, it'll give them time to talk to more people. All right? Because you have several, so, all right. Okay, Mr. Williams, you're before the court on a municipal ordinance violation and a misdemeanor capias. Also a municipal ordinance violation. The court finds probable cause. What does Mr. Williams wish to do?
Judge, on count 2, which is the county ordinance, it's for a panhandling offense. I did discuss with Mr. Williams that I believe that ordinance is unconstitutional. He told me that it doesn't matter. He just wants to resolve this case, so he wants to waive his rights as to the attacking the constitutionality of that ordinance. So he'd like to plead no contest to count 2.
Okay.
The state's offer on count 2 would be an adjudication time served.
And are you representing him on count 1?
No, Judge, that's out of the city of Lauderdale Lakes. I have no idea who would be representing
Are
him.
you on that one, Mr. Plant, on Willie Williams?
Yes, Your Honor.
Do you have you have that?
Yes, Judge, I have the order.
Okay, all right. So on the state, do you have an offer from Mr. Williams? Is it no, it's a,
Yeah, on the first one, no. On the county, though,
No.
county, we do handle the county cases, Your Honor, the state does.
Okay.
It would be a time served.
Okay.
offer.
all right. So as to both counts, I'll sentence him to adjudication and time served.
Judge, just give me a moment. He's a little hard of hearing, so let me let him know what the offer is.
Sure.
Yes, sir. Yes, ma'am.
All right, Mr. Williams, can you hear me? Did you,
Judge, he can't hear you very well. The sound keeps coming, going in and out.
how are we gonna fix that? Because I have to know that he hears me, even if I don't go through the whole plea colloquy, I have to,
We can hear you now, Judge.
Okay.
It's just that not all the time.
okay. All right, Mr. Williams, can you hear me?
What's it?
She asked you if you can hear her.
Now I can.
Okay,
I think you heard me.
all right. Mr. Williams, you want to resolve your case today?
Judge, I can tell him what
Please.
you're saying, Judge, if you don't
Please.
mind. The judge asked you if you want to resolve your case here today.
Yes, yes.
All right, and what plea do you want to enter?
What plea do you want to enter?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Yes, sir.
Thank you, Judge.
All right. Okay. All right, Gregory Dellinger.
Auntie, Your Honor.
All right, Mr. Dellinger is before the court for a violation of injunction. It's a domestic violence. It's a change of charge. It's a change of charge?
Yes, Judge, it was an upfile from a misdemeanor to a felony. The upfile is based on prior violations, which I have no reason to believe that Judge McHugh was not made aware of at his original first appearance. She set the bond at $3,000 in order no victim contact. I just asked that bond and the same bond and release conditions be imposed.
All right, so, Mr. Dellinger, just so you understand that the charge has been upgraded, but at this time, I'm gonna leave the $3,000 bond in place with no victim contact, okay?
Okay.
All right, sir, good luck. James Miller?
Come on, bro. Oh, do you like next? Oh, you done. I gotta take you
All
back.
right, Mr. Miller is before the court this morning on 2 charges of misdemeanor capias. And the court finds probable cause. They're for petty theft, both petty thefts, and these are capiases from March 5th and March 6th of this year.
Judge, in speaking with Mr. Miller, he indicated he's before Judge Coleman. He indicated Judge Coleman has ordered him to bark IRT already. He's just pending placement in that program, waiting for a bed. So we would ask, if that is accurate, that on counts 2 and 3, we ROR him to bark as well.
Do we have any information as in regards to that?
It does appear he was on a pending felony theft to bark.
All right, so I'll ROR him under the same conditions of his other charge to bark, okay? Yes. Jeffrey Simmons. Where do we have Mr. Simmons?
He went to regular court, Judge.
All right, thank you. Mr. Simmons is in court.
Your Honor?
Yes,
I can check, but I think this count was add charge to the case he's in court on.
okay.
And I'm just checking to see what he's scheduled for court. But if it's an arraignment, then naturally he would be advised of this charge. And that's exactly what he's scheduled for arraignment this morning before Judge Fine at 8:45.
So we don't need to reset it?
I would say no, because he's gonna be
Well,
advised of the
It's also
battery.
showing that, he would.
No, but he doesn't need to be here for the court to find probable cause. Yeah, I'm sure he's gonna be brought
It's
back
got a
before Judge
status
Fine
for
for the
tomorrow.
status tomorrow.
It is scheduled for a status tomorrow, so I'll find probable cause.
Thank you.
Okay. All right, Dwayne Bradbury. All right, Mr. Bradbury is before the court for 3 add charges, driving, it's 3 misdemeanor capias. Driving under the influence, driving while license suspended, and unlawful tag or sticker. Did not show for calendar call on May 29th. So, Mr. Bradbury, I find probable cause. Your division judge did impose a $5,000 bond on count 5.
Shields.
And you have court tomorrow before your division judge, okay?
Thank you.
All
You
right,
notice
sir.
anything weird about this?
Alan Veal,
Okay, James.
Exactly, Sheila.
yes.
My name's Brian Reedy, I'm an attorney with the Public
Do we need him to
Defender's
come back?
Office.
Mr. Bradbury, can we bring Mr. Bradbury back, please?
Alright,
You gotta
James,
talk
you got a grand
fast.
theft with a $1,000
He's-
bond. Unfortunately, he's with a couple of probation violations. Those are no bond holds. I don't see a court date for you yet. Are those Broward County probations or are they out of county?
It looks like what happened, Your Honor, he was
I don't see a court date.
arrested May 21st on a out-of-county hold and a capias on the same DUI case.
Fleeing and eluding.
It looks like,
both from
based on when this capias was issued on May 29th,
actually, but you
that he
have no
wasn't
bond
brought
holds on
before Judge
those.
Brown,
You're going to resolve the grand
and, I'm sorry,
theft
Judge Gottlieb,
division judge.
and a capias was reissued again. So he's actually being held twice on the same case number. I'm just asking that he needs to be brought in front of Judge Gottlieb, and this needs to be straightened out in front of Judge Gottlieb.
Can I speak for a second?
Sure, sir.
I was informed that my court date was scheduled twice. It was never reset. There was miscommunication between the clerk of court and the jail, meaning that my name on the docket is spelled miscorrect, B-U-R-Y rather than B-E-R-Y. Once the clerk of court is trying to send the information over to the jail, they were unable to locate which jail I was located at to inform me that I had court, that I was on the docket for the deputy to realize that I'm on the docket for court for them to actually take me to court.
And the reason, Your Honor, I'm suggesting to let Judge Gottlieb figure this out, the total bond set on the original capias was a total of $5,000, which hasn't been posted, so he's still being held on that $5,000 original bond.
So, just for Mr. Bradbury's, because this paperwork is showing that he has an ad charge of 5, 6, and 7. We're saying that those should not be ad charges because he already has a capias on those 3.
I don't really know, here, can I see that, please? It might help, Your Honor.
And what really occurred was my first
Mr. Bradbury, just hold on.
Hang
just a
on, Mr.
moment,
Bradbury.
okay?
I'm going to try and get to the bottom of it right now, okay?
So when this other capias was issued, he was in custody. Is that what we're saying?
Yes.
Okay. All right. Well, you go before Judge Gottlieb tomorrow, sir, and
At what
he's
time?
at 9 o'clock. You have a hearing before your division judge. And
But
then-
here's the issue, once
Sir,
again.
sir, tomorrow, you will be able to speak with your division judge to get everything all straightened out, okay? All right,
Okay.
all right, Alan
I
Veal,
know that, and let Judge Gottlieb figure it out.
all right, Mr. Veal is before the court. Count 1 is petty theft. Count 2 is battery causing bodily harm. Count 3 is trespassing, occupied structure or conveyance. And the court finds probable cause.
Your Honor,
Yes, ma'am.
Mr. Veal is currently on pretrial supervision in case number 19006869 CF10A, possession of cannabis less than 20 grams or synthetic cannabis 3 grams or less, and introduction of contraband into detention facility.
Give you this by
He was released to pretrial supervision on May 30th. At this time, we're requesting a revocation of supervision.
Okay,
Judge, if the court is inclined to revoke his status on the previous case just spoken about, we're then going to ask that the court ROR him on all 3 of these counts and allow him to go before his assigned judge to deal with the revocation.
well, in either case, he'll go before his division judge on case number 19006869 CF10A. These are felony charges that Mr. Veal was placed on pretrial on May 30th, is that correct?
Yes, Your Honor.
All right, and then Mr. Veal is before the court today on a petty theft, battery, and trespassing charge. So as to the 6869 CF10A, I am going to revoke his bond, and I am going to hold him no bond until he sees his division judge. And then on the new arrest, on he's got $1,000 bond that I'll leave in place. Okay? Jonathan Krakauer. And then
Your Honor,
I'll
just
call-
ask for an order of no contact and return to
And
that
no
Walmart.
contact, sir, with the victims.
Thank you. Really? So where did he celebrate?
All right, Jonathan Krakauer, Mr. Krakauer, you're before the court for one count of petty theft. Count two is an out-of-county hold out of the Lake County. That has a bond that is attached to it for $2,000, and that's not for magistrate. The court finds probable cause, and your bond on count one is $25. All right, I'm going to call some of the cases from Mr. Plant. On page 9, Alfonso Fernandez Gonzalez.
Krakauer.
All right, where do we have Mr. Gonzalez?
I thought you were.
Anyone? Alfonso Fernandez Gonzalez? Okay. All right. Mr. Gonzalez, you're before. Sir, you're before the court on 3 misdemeanor cases, and those are. No, that's not, Mr. Plant, these are state charges. Okay. All right, so these cases are, well, count one is possession of cannabis, count two is resisting officer without violence, and count three trespassing. And the court finds probable cause, and Mr. Fernandez does have court tomorrow before his division judge. Ma'am, you're here on that case? Okay, good morning, how are you?
I am here, I am his mother.
Yes.
To request a management act on him because he has an addiction which he has no control over, and he has not attended outside help. So I would like to request for him to be posted in a rehabilitation center.
I think, Your Honor, if I may, probably the most productive thing his mother could do. These cases are in drug court, so he'll be in front of Judge Lerner Wren tomorrow, and she could probably facilitate or take action in a
Right.
more productive way.
So based on, there's a specialized court and that he is already in, and that judge issued these cases, and he goes before her tomorrow. And from that court, they're able to provide different services, and she'll be better equipped to handle those, okay? All right, so he'll be before Judge Lerner Wren tomorrow. Yes, not in this room, but on the 6th floor.
6 or tomorrow, what time?
Tomorrow at 10:30, it says, that he's scheduled for hearing. Okay?
Okay.
All right, good luck, ma'am.
Thank you.
All right, I'm sorry? It's already there. It's Judge Lerner Wren, yes. Anthony Pendergrass on page 20. Anthony Pendergrass.
No, it's not she does
let's
drug
go
court
and
now,
go.
too.
Oh, somebody else signed in. Oh, I'm sorry.
Yeah.
Okay. All right, on page 20, Anthony Pendergrass. Good morning, folks. Mr. Pendergrass is before the court on 3 counts of burglary, unoccupied conveyance unarmed, and the court finds probable cause. And I'll hear from the parties as to bond.
One moment, Judge.
Judge, in speaking with Mr. Pendergrass, he has been a Broward resident his entire life. He indicated he's never missed a court hearing before. He does have gainful employment. He works at Tom Jenkins. He indicated he's not on any form of supervision. He does actually have 5 children that he provides for. One of them actually stays with him. The other 4 are with the mother of the children. Based upon his financial situation, we are asking the court if the court could set a $1,500 bond on counts 1, 2, and 3. That would enable Mr. Pendergrass to bond out. Otherwise, anything more than that is going to become a financial hardship for him.
Let's see. Okay. Your Honor, I'm going to be requesting $5,000 bonds on each count. Mr. Pendergrass is out on bond right now for a misdemeanor possession of cannabis. In 2014, he was convicted of possession of PVP, a year and a day state prison. 2010, burglary of a dwelling. 2010, burglary of a dwelling. 2 separate cases. He violated probation, was sentenced to 87 months in Florida State Prison. 09, burglary of a dwelling, grand theft, resisting without violence. He violated probation, 87 months in Florida State Prison. Trespass in 09 with the violation of probation.
Okay, ma'am, is there something you wanted to say? You don't, I'm sorry?
That would be, too hard to post that much money, and I take care of his daughter.
That will, what will be too harsh?
$5,000 for each count,
Okay,
and I don't even have no help with her, and I have my own kids, I have 3 kids myself, and I work myself.
okay.
Your Honor, I just want to advise the court. I'm showing on the Department of Corrections database that Mr. Pendergrass was just released from state prison April 5th of 2019.
All right, I am going to impose $1,500 bond on each count, but that's also going to be with a level 2 GPS anchor monitor. Okay. All right. Okay, Alexandra Dominique.
And Judge, I don't mean to cut everybody off, just so the court is aware, at some point, we are going to need a Spanish interpreter for 2 individuals.
Okay. On page 3, Alexandra Dominique.
Yes, Your Honor, that would have been North Broward. She's a medical reset.
Okay.
What's that?
And then on page 9, John Loden.
Couple hundred people? That's what it looks like.
Is that Maine, John Loden?
That's like a couple thousand.
All right, Mr. Loden, you're before the court this morning. There's 1 count of resisting officer without violence. Count 2 is municipal ordinance violation for an open container. The court finds probable cause. And what does, Mr. Loden has a state charge and a municipal ordinance matter. What does Mr. Loden wish to do?
Judge, at this time, is the state willing to make an offer on count 1?
The offer on count 1 would be an adjudication, time served.
It's a time served offer.
It's a time served.
Can you hear us? Time served.
Can now, time served on
yeah.
both counts?
Yes, Corey.
Start writing everything down, just holding the signs.
I know.
Judge, in speaking with Mr. Loden, if the court is willing to accept his plea, he would be willing to enter a plea of no contest.
All right, Mr. Loden, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Loden, do you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, I am not.
Do you need any more time to speak with your attorney?
No, I do not.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, I have not.
And sir, you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Okay, thank you.
Okay?
Grant Harvard on page 10.
She don't need to see me, right?
No.
He has a city case.
All right, Mr. Harvard's got a municipal ordinance violation matter on a KPS. The KPS was issued on May 2nd. What does Mr. Harvard wish to do today?
If possible, Mr. Harvard would like to enter a plea to the charge.
Oh, okay. It's a municipal ordinance violation charge. Just
Yep, I'm here for you.
okay, so
He wants to do that.
if you wanna resolve the case, sir, it'll be adjudication and time served.
Yep.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
I swear.
Okay, you can put your hand down. And sir, is anyone forcing you to resolve your case?
Nah, I'm doing it on my own.
Are you under the influence of drugs or alcohol?
No, Your Honor.
And do you need any more time to speak with an attorney?
Nah.
Is,
I'm good.
okay, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yeah, I'm just do the time serving.
Okay, I know. I have to ask you all these questions to take the plea.
Yes.
So
Yes.
okay.
Okay.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And sir, one last question. Do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
All right, and what plea do you wish to enter at this time?
Yes, no contest. No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Judge, I think I missed one on page 10. Gerald Jackson?
That's next.
Okay. I went out of order.
All right, Mr. Jackson, on page 10, Gerald Jackson. All right, Mr. Jackson has one count of petty theft, and then there's a municipal ordinance, a KPS violation, and so the court finds probable cause. And what does Mr. Jackson wish to do today?
If possible, Mr. Jackson would like to enter a plea to both counts,
Does the
for both
state-
cases.
All right, does the state have an offer?
Yes, on count one, it'd be time served, no return.
All right, so then,
Judge, if willing, Mr. Jackson would like to enter a plea and accept the offer.
all right, so it'll be the same sentence for both counts, adjudication and time served. So, Mr. Jackson, please raise your right hand.
Yes, ma'am.
Do you swear or affirm to tell the truth, sir?
Yes, ma'am.
You can put your hand down, Mr. Jackson. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served on both counts, okay?
Thank you, ma'am.
All right. And then Caleb Ferguson,
Yeah. 2 weeks.
on page 10, Caleb Ferguson. All right, Mr. Ferguson has 2 municipal ordinance violations, trespassing on school property, possession of marijuana. The court finds probable cause. What does Mr.
Is the state in a
Ferguson?
position to make an offer?
One moment, Your Honor.
Other city violations.
Aren't they both city violations?
Both municipal, Your Honor. Out of Fort Lauderdale.
Sign on the yellow line.
The only thing I would ask, if the state doesn't mind, can you let me know if he has any prior criminal
One moment,
history?
Judge.
James Rainey. Tyrone Peterson. Bruce White. Joseph.
I'm not seeing anything local, Your Honor.
Okay. All right, Mr. Ferguson, if you wish to resolve your case today, it'll be a withhold adjudication and court costs.
I couldn't hear you.
Okay, if you ask him to turn off the mic, at the main jail, can you turn off the mic until he's ready to speak? Thank you very much. Can you hear me better now? Okay. All right. So I know that I can't hear you until they turn the mic back on. So just listen, and then when they turn it on, you can tell me what you want to tell me. But you have 2 municipal ordinance violations, right? There's a trespassing on school property and the possession of marijuana. I don't know if you heard me ask the state to tell me if you have any prior criminal history. They told me that they have not been able to find anything local. So at this time, I'm offering you to resolve your case, withhold adjudication, which means no conviction on your record for these charges, and then court costs that you would have to pay, all right? So if you wish to accept that today, you can resolve your case today. Otherwise, you will have to post your bond or talk further to your attorney. So what do you wish to do?
I'd like to resolve my case today.
All right, so then I'm going to ask you some questions. I'm gonna make you swear in, and then I'm gonna ask you some questions, and then we'll take a plea, okay? So please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. All right, Mr. Ferguson, do you understand everything that I've said to you today?
Yes, ma'am.
And is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, you have the right to go to trial, but by taking a plea today, the case is going to be over and you're giving up that right to go to trial. Is that what you want to do?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter? Your options are guilty, saying that you are admitting that you did it, or no contest, which means that you're not admitting or denying, you're just saying that I want to resolve the case with that plea today.
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs on both counts. Good luck, sir. All right, and do we have Stephen O'Neill today?
It's a medical reset here.
All right. All right, thank you.
Spanish interpreter is present.
Yes, who needs a Spanish interpreter?
There's a couple of fellows at the main jail, I believe.
Page 11, Vasquez would need a Spanish interpreter.
Is that?
Joel Ramos Vasquez,
Okay.
as well as Morales. Page 19 of your docket.
Okay. All right. Joel Ramos Vasquez, if we can have him, please. Have interpreter. Can you raise your right hand, please? Have you been sworn in already this morning? Do you swear for him to translate from Spanish to English and English to Spanish?
Yes, I swear.
Okay, thank you. All right.
Just so you're aware, he refused the services of the public defender.
Are you sure?
Rehusó los servicios del abogado defensor público. Seguro.
All right. Joel Ramos Vasquez,
Okay, Joel Ramos Vázquez.
you are before the court today, sir,
Señor, usted está delante del tribunal en el día de hoy
for count one, operating without a valid driver's license,
por cargo número 1 es estar operando un vehículo sin tener una licencia de conducir válida.
and count two is a KPS
Y el cargo 2 es una orden de captura que hay
for the same charge, operating without a valid
por el
license.
mismo cargo de estar operando sin una licencia válida.
It is an old KPS from 2017,
Es una orden de captura vieja del 2017,
where you failed to appear for calendar call.
donde usted falló en presentarse en la lista de causas en el tribunal.
You do have court tomorrow before your division judge.
Usted sí tiene cita en el tribunal mañana ante de su juez de la división suya.
And since you have declined the services of the public defender, is that correct?
Y como usted rechazó los servicios de la defensa pública, bueno, ¿es eso correcto?
We have
Oh,
to
the
turn.
mic.
We have to turn the mic on. Sorry.
No entiendo esa parte.
I didn't understand that part.
There are attorneys from the public defender's office. The gentleman in the blue shirt
Que ahí hay abogados de la defensa pública. El señor ahí de la camisa azul,
is an attorney from the public defender's office.
él es un abogado de la oficina de la defensa pública.
I'm not telling you what to do,
Yo no le estoy diciendo lo que tiene que hacer,
but you do have the option of having the public defender's office represent you,
pero usted sí tiene la opción de que la oficina de la defensa pública lo represente.
or you can hire private counsel,
O si no, usted puede contratar su propio abogado privado.
or you can represent yourself if you want.
O si quiere, también se puede representar usted mismo.
So my question is, are you declining the services of the public defender?
Entonces, la pregunta que le hago a usted, señor, es que si está rechazando los servicios de la defensa pública.
Sí.
Yes.
Okay, then what do you wish to do today, sir?
Ok, entonces, ¿qué es lo que usted quiere hacer hoy, señor?
Si mañana yo voy a representar, entonces yo me voy.
So, if tomorrow I have to represent, then I'll leave.
Well, tomorrow you have court before your division judge.
Bueno, mañana tiene usted una cita al frente de su juez de la división suya.
So is that
Ok, yo me voy a presentarme.
Okay, then I will show up. I will appear.
Well, you will still be in custody and they'll take you to court tomorrow unless you post your bond.
Bueno, usted todavía va a quedarse detenido. Ellos lo van a llevar allá, a menos que usted no pague su fianza.
You have $25 bond on count one
En el cargo número 1 tiene usted la fianza de $25
and $500 bond on count two.
y $500 en el cargo número 2.
Okay?
¿Entendió?
Ok, pero yo puedo pagarlo hoy mismo, ¿verdad?
Okay, but can I pay that today, right?
Yes, if you can post it today.
Sí, sí, lo puede pagar.
Okay?
Ok, ¿cuál es la manera de pagar esa cantidad?
Okay, how do I pay that amount?
They'll let him know.
Ellos le van a avisar, ellos le explican allá.
Okay? All
¿Está
right.
bien?
Good luck, sir.
Buena suerte, señor.
Okay. Okay, gracias.
All right, Ivan Morales. All right, Mr. Morales. Mr. Morales is before the court today
Señor Morales, si usted está presente delante del juez hoy
on a charge of sexual battery,
con el cargo de agresión sexual
a victim 18 years or older.
contra una víctima de 18 años de edad o mayor.
All right, the court finds probable cause,
La Corte sí encuentra que ha habido causa probable.
and I will hear from the parties as to bond.
Ahora oigo de las partes sobre la fianza.
Thank you, Judge. In speaking with Mr. Morales, based upon his financial situation, we're going to ask that the court not set a monetary bond, but in this matter, place him on pretrial release.
He hablado con el señor Morales y basado en su situación financiera pedimos que no le impongan una fianza muy alta, sino que lo dejen salir bajo libertad en el programa previo a juicio.
He does live in Boca Raton with his mother and sister.
Él sí vive en Boca Ratón con su hermana y su madre.
Unfortunately, at this time, he's not working nor has access to money.
Lamentablemente en este momento no está trabajando y tampoco tiene acceso a dinero.
According to Mr. Morales, he's never been in trouble before. This is his first offense.
Según el señor Morales, no ha tenido problemas anteriormente, es la primera ofensa.
Based upon that, Judge, we are going to ask for some form of pretrial release, and just to let the court, let it be known, he does have a passport. He is have a Colombian passport, so if the court also needs that to be addressed, we'd have no objection to surrendering of the passport.
Por lo tanto, pedimos que le dejen salir en libertad previa a juicio y para dejarle saber al tribunal, él sí tiene un pasaporte colombiano y si quisieran tratar con ese pasaporte tampoco habría ningún problema.
Your Honor, in addition to the passport release condition,
Además de la cuestión del pasaporte,
If you turn off the mic, okay, thanks.
thank you, Judge. The state would be requesting a $10,000 bond,
el Estado estaría pidiendo una fianza de $10,000
pretrial release with a GPS monitor level 2,
y a libertad previa a juicio con un monitor electrónico a nivel 2
no victim contact.
y tampoco puede tener contacto con la víctima.
And Your Honor, I'm requesting these conditions because you may recall
Y si su señoría se recuerda, yo estoy pidiendo estas condiciones
you had the first appearance for his co-defendant,
porque usted tuvo la primera comparecencia de su coacusado,
Jose Cobo Becerra,
José Cobo Becerra,
last Friday, and that was the bond and release conditions you set for him.
y eso fue lo que se puso como las condiciones de libertad el último viernes pasado para él.
I didn't remember that it was a co-defendant, but I remember the probable cause affidavit.
No recordaba el coacusado, pero sí el affidavit.
And I was
Recordaba de causa
wondering
probable.
why he was before me again on the same charge.
Me
But it
preguntaba por
wasn't
qué
him.
estaba antes de mí con el mismo
Yes,
cargo.
and in speaking of that probable cause affidavit,
Y hablando de esa affidavit de la causa probable,
it would appear that the alleged victim in this case
parece ser que la alegada víctima en este caso
attended a party,
estaba en una fiesta
became voluntarily extremely
y
intoxicated,
voluntariamente fue muy intoxicada.
went to lie down in a bedroom inside the
Se
house.
recostó en un dormitorio dentro de la casa.
Mr. Morales apparently was not the first person she claims had intercourse with her.
Y señor Morales no es la primera persona que ella reclama que tuvo relaciones íntimas con la
While she
víctima,
was voluntarily intoxicated.
mientras que estuvo intoxicada voluntariamente.
Mr. Morales, in his statement to the police, admits that he did have intercourse with her.
Y el señor Morales en su declaración a la policía admitió que sí tuvo relaciones sexuales con ella.
He considered it to be consensual
Y él consideró que fueron relaciones con consentimiento,
based on the victim's sexual advances that she had made toward him earlier that night.
basado en los avances sexuales que la víctima hizo hacia él más temprano esa misma noche.
The officer who wrote the report claims that there were multiple inconsistencies in Mr. Morales' statement,
El oficial que escribió este informe dijo que había múltiples inconsistencias en ese informe que dio el señor Morales,
yet he is unable to state one of them in his affidavit.
pero nunca pudo poner ni una de ellas en su affidavit.
So I think that there's a lot yet to be learned about this case.
Así que pienso que hay mucho todavía que aprender sobre este caso.
And in light of Mr. Morales' financial situation,
Y en vista de la situación financiera del señor Morales,
that's a factor this court should determine or should use in determining an appropriate
ese es un factor que este tribunal debe de tomar en cuenta
conditions of pretrial release.
cuando está pensando en las condiciones previas a juicio.
Your Honor, I would note this is a filed case. It has been fully investigated,
Yo noto que este es un caso que ya se ha tramitado y se ha investigado a plenitud,
not only by law enforcement,
no solamente por agentes del orden público,
but also by the State Attorney's Office.
pero también por la oficina del abogado del Estado.
I'm really not clear on
Realmente no estoy claro
mitigating points of Mr. Reedy's argument,
de cuáles son los puntos mitigantes del argumento del señor Reedy,
but the allegations are that the victim was unconscious
pero las alegaciones
at
son
the
que la
time
víctima
of this
estuvo
sexual
inconsciente
assault.
durante esta agresión sexual.
She could not have possibly consented,
Ella no era posible que ella diera su consentimiento.
regardless of any comments she made earlier in the evening
No
to Mr.
obstante cualquier
Morales.
comentario que haya hecho más temprano esa misma tarde o noche.
I would hardly consider this case being fully investigated
No podría yo considerar que este caso ha sido investigado a plenitud,
when the only agencies investigating it
porque las únicas agencias que lo han investigado
are the prosecution.
es la Fiscalía.
This case will not be fully investigated until the defense conducts its investigation.
Este caso no estaría investigado completamente hasta que la defensa pueda hacer su propia investigación también.
We don't know even if this woman has given a sworn statement
No sabemos ni siquiera si esta mujer ha dado una declaración jurada,
or what she remembers
ni qué es lo que ella se recuerda,
or who she remembers.
ni a quién ella recuerda.
So I think that these are factors the court should be taking into consideration
Creo que estos son factores que
in
el
determining an
tribunal
appropriate bond in this case.
debe de tomar en consideración cuando está pensando en la fianza apropiada en este caso.
Okay, for first appearance purposes,
Ok, por el propósito de esta primera
as
comparecencia,
all attorneys are aware,
como saben todos los abogados aquí,
the court makes a finding of probable cause based on the affidavit
la Corte encuentra causa probable basada en el affidavit
and the information that's provided to the court.
y la información que se le ha presentado al tribunal.
This is not the trial,
Este no es el juicio,
and so if Mr. Morales has defenses to be brought,
Así
that will be heard at another time.
así que si el señor Morales tiene algunas defensas que quiera utilizar, eso es para presentarse más adelante en otro momento.
All right, the court finds probable cause,
La corte sí encuentra que ha habido causa probable.
and Mr. Morales will have a $10,000 bond
El señor Morales tendrá una fianza de $10,000
with a level 2 GPS.
con un nivel 2 monitor electrónico de GPS.
He's required to surrender his passport,
Es obligatorio que él entregue su pasaporte
and I will ask the state to prepare an order as such.
y voy a pedir que el Estado prepare una orden con todo lo indicado.
And Mr. Morales is to have no contact with the victim
Y el señor Morales no podrá tener ningún contacto con la víctima
until further order of the court.
hasta que haya otra orden más adelante del tribunal.
And Your Honor, I imagine as part of your order regarding the passport
Y me imagino como su señoría, como parte de su orden acerca del pasaporte,
would be an additional order that Mr. Morales is not to apply for a passport during the pendency of the
sería otra
case.
orden adicional, otra condición que no pueda solicitar por otro pasaporte.
That is correct.
Eso es correcto.
All right, is there anyone else who needs a Spanish interpreter?
¿Hay alguien más que necesite el intérprete de español?
All right, hearing nothing, thank you very much.
You're welcome.
All right. Akeem Brown. Okay, so Mr. Brown's bond has been posted. Is he there? All right, Mr. Brown, you have, you're before the court on 2 misdemeanor cases, but I've been advised that your bond has been posted. Okay? Good luck, sir. Richard Walker.
Judge, I'm so sorry.
Yes.
In regards to Mr. Brown, is the state willing to make an offer?
Oh.
Bond it out. One moment.
If the bond is already posted and making it outside circulate, that means the bond is
He's already paid it. So probably not gonna get their money back.
State have enough?
I'm looking that
Okay.
over right now, Judge. Offer would be withhold court costs on both cases.
Okay.
Just mark down what it is. I mean,
Mr. Plant, if you have orders for me to sign, you can just pass them up.
Judge, at this time, in speaking with Mr. Brown, he would be willing to accept the state's offer.
All right, Mr. Brown, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Brown, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Brown?
No contest. No contest.
I accept your no contest plea, sir. I find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs on both counts. Good luck, sir. All right, Richard Walker. Okay. Is he out? I guess he's out. And then Jose Ramirez. Ramirez bonded. Dexter Fields. All right, Mr. Fields is before the court this morning. It's an ad charge for a grand theft. And the court finds probable cause.
He's got a $1,000 bond for grand theft on count one, Judge.
All right, so we'll leave the $1,000 bond on count two. Okay.
Judge, is there any chance the court would consider, in lieu of a monetary bond, pre-trial release?
Does Mr. Fields have a criminal history?
The financial situation would be tough for him.
He's got a pending felony
Pending felony.
for possession of substituted cathinones.
And did he post bond on that?
I'll check. He posted a $1,000 bond on a possession of MDMA. I'm sorry, no, on the case that he was out on, I guess he was on pretrial. He got picked up for a violation of pretrial and then got ROR'd.
I'm gonna deny pretrial at this time. He has a $1,000 bond. Troy Thomason.
On your violation, you're gonna have to come up with $100 to get you out of here today. Otherwise, we'll get you in front of the real judge.
All right. Troy Thomason.
North Broward, Your Honor.
Thank you. Okay, Mr. Thomason, you are before the court this morning. Charge number 1 is DUI, alcohol, or drugs. 2 is driving while license suspended. 3 is disobeying traffic signal. 3 is disobeying or avoiding red light. 3 is disobeying traffic device. 5 is felony violation of probation, which has a no bond hold. And you do have court tomorrow before your division judge at 8:30.
Your Honor?
Yes.
I'm going to ask to be heard on count 1, which my understanding for a fourth or subsequent DUI, it's supposed to be a hold for magistrates. Your Honor, I'm going to be asking for a
Yes.
$25,000 bond. He was just placed on 5 years probation for felony DUI and felony driving on a permanently revoked driver's license, which count 2, I imagine, will also end up being filed as driving on a permanently revoked driver's license.
When you say just when,
July 27th of 2018.
okay?
Again, Judge Bailey, part of his sentence involved a lifetime revocation and a 10-year interlock restriction. So any vehicle he's to be operating, he's supposed to have an interlock device on it to begin with. I believe Mr. Thomason poses a significant danger to the community, to motorists in the community. He clearly has no regard for either not driving unlawfully and not driving while under the influence. So I'd also be asking, should he be eligible for release at some point in this case? Pretrial release with a TAD monitor, no alcohol or intoxicants, random testing, no driving.
Well, Judge, Mr. Thomason indicated to me that he has counsel Chris O'Toole. I called the office of a local lawyer named Chris O'Toole, and they did not seem to know anything about Mr. Thomason. So I don't know if he has private counsel at this point or not.
Mr. O'Toole represented him on the case that he's on probation for. I don't know if he retained him for this matter.
So, Mr. Thomason, if you did not retain the attorney for this new arrest, they're indicating that they're not representing you or that they didn't know who you were, so I don't know if it's a local attorney?
I have not had an opportunity to make a phone call to reach out to him, but I have, he does have retainer money that I have paid him, so.
So is he an attorney here in Broward County? Well, it doesn't even.
Yes, he is. Yes, Christopher Toole, he is an attorney practicing here. So
Okay.
I would like an opportunity to try to reach him.
Well,
I'm not sure they actually got through to him.
The attorney in the courtroom did make a phone call to Mr. O'Toole's office, and they said they didn't know who you were, so.
Yeah, I think that was mistaken. He definitely knows who I was. I spoke to him just recently, this last week, and he is my representing attorney. I would like an opportunity to reach out and talk to him, but I have not had an opportunity here to place a phone call.
Okay, well, you will, do you know the number?
No, I don't have access to a phone book. If I could access to my phone, I do have it on my telephone.
Oh, okay,
I might have a number for him, Judge, that
Okay.
Mr. Plant just gave me,
okay.
if you want to give him a try. It's a 954 295
Okay,
1600.
okay. Good morning. Is this Mr. O'Toole?
Yes, yes it is.
This is Judge Jackie Powell, and I'm calling from First Appearance Court. And I need to let you know you're on speaker and we're in open court. And the reason why I'm calling is because I have before me this morning Troy Thomason, and Mr. Thomason tells me that you are his attorney.
Yes, I am.
All right, so I didn't know if you have been retained or if you've spoken to him in regards to this new arrest. And so that, I told him I'd try and make the phone call just to see.
I didn't know about it. Haven't been retained, but I have no problem, stepping in.
Okay, well, Mr. Thomason is before the court this morning, sir. He has 1 count of DUI, alcohol or drugs, 4th or subsequent offense. Count 2 is driving while license suspended. A 3rd or subsequent offense. Count 3 and 4 are traffic infractions. And then he does have a violation of felony probation, which is count 5, which has a no bond hold. And he has court tomorrow before Division FG at 8:30. Okay?
Division FG at 8:30.
Yes.
Right.
And at this time, because of the prior DUIs, the state is asking for a $25,000 bond on the DUI charge, in addition to having a TAD monitor, no alcohol, no driving. I believe he was placed on probation last July, and the charge there was also a felony DUI. So.
Your Honor, would the court be amenable to reducing that bond? He's been a lifelong resident of Broward County. He owns his own business. He's certainly not a flight risk, and it's if you could reduce it to something more affordable, like $10,000, I know he could afford that.
Okay.
Your Honor, just also let you know, as far as his prior DUIs,
Yes.
this is actually more than his fourth, because in 2014, he pled out to a felony DUI in Broward with an enhanced breath.
Okay. All right. So, I will impose on count 1 the $10,000 bond, but that's also going to include that he's gonna be on a TAD monitor on pretrial release. No alcohol or intoxicants, no driving, until further order of the court.
Thank you, Your Honor.
Okay, sir, did you hear all of that?
Yes, and would I have a chance to talk to Mr. O'Toole or perhaps in the morning at court?
I'm sure your attorney will be in touch with you, okay?
I'll see you in the morning, Troy.
He'll
Thank
see
you.
you in the, okay.
Your
All
Honor.
right, good luck. Thank you, Mr. O'Toole.
Thank you very much.
You're welcome.
Bye.
All right, Brandon Johnson.
Back in Southbridge.
Brandon Johnson. Okay, Mr. Johnson, you're before the court this morning. Count 1 is burglary, occupied dwelling unarmed. Count 2 is petty theft. Count 3 is possession of cannabis 20 grams or less. And count 4 is a misdemeanor capias. It's a municipal ordinance violation on 4. And the court finds probable cause. And I'll hear as the bond.
Sure.
Judge, I was not able to get any information from Mr. Johnson. He was not cooperative.
Okay,
Your Honor, I'm going to be requesting a $15,000 bond on count 1, noting that this is someone's home. I would also note he has a pending theft before Judge Lerner Wren. He was actually scheduled for arraignment on June 3rd, this Monday, the day before this incident. According to Odyssey, he did not appear for his arraignment. It does not indicate if a capias was issued, and if so, what the amount on the capias it was. He also has a prior 2012, 2 counts of aggravated assault on a law enforcement officer, possession of cocaine with intent to sell or distribute, fleeing and eluding law enforcement. He was sentenced to just under 50 months in state prison as a habitual offender. 2011, possession of cocaine with intent, resisting without violence. Disorderly conduct 2010, trespass 2010, possession of cocaine 09, possession of cocaine with intent, resisting with violence, and tampering with evidence 2008. Nothing further.
all right, on count 1, I am going to impose a $15,000 bond. In addition, if Mr. Johnson posts his bond, he'll be on a level 2 GPS. No return to this location, okay? Yes. Okay,
I ain't got no way to pay that type of stuff. And the burglary unoccupied dwelling, I didn't even take anything.
all right. All right, good luck, sir.
Good luck.
William Devon.
Young, you're gonna be next.
Where's,
He
Mr.
declined the
Devon?
PD.
Okay.
Judge, we still have a recall from page 11, Mr. Krakauer.
Okay, well, no, well, wait, what happened with Mr. Devon? I know he declined PD, but where is he?
He's using the restroom.
Oh, okay. And then, I don't, Krakauer?
Thought we handled it.
We handled Krakauer.
No, we didn't. That's you, right? Yeah.
No, I don't believe we did.
Got called.
He got called, but then was asked to sit.
I thought. I thought Your Honor kept the bond in place because he's gotten out of county.
I thought we handled it.
Well, I see he has two matters, an out-of-county hold, which we obviously can't address. Would the state be willing to offer or give an offer on count one, petty theft, second degree, first offense?
I'm sorry, oh, hold. You're looking for it?
And Your Honor.
Okay. Yeah, I thought we handled it. He has an
Definitely did.
out-of-county hold, a misdemeanor hold in Lake County, which is he has a $2,000 bond. It's not for magistrate, and then he's got the petty theft.
And I wasn't inclined to make an offer because they involve essentially similar, if not the same charges, type of
We
offenses.
left the $25 bond in place on the petty theft. Okay, and the state's not making an offer on the petty theft.
Would the court be inclined to ROR him on the $25 count?
Your Honor, considering that the offenses are of the same nature, yes, frankly, a bond increase would probably be appropriate. He's wanted out of another county. I don't have much confidence of
I
his
don't know.
voluntary
No.
return.
I'm gonna deny that at this time, okay? All right, so,
Thank you. Judge William Devon is back.
okay, so let's handle Mr. Devon.
And again, he declined the services of the PD.
Okay. All right, Mr. Devon, you're before the court for driving while license suspended habitual, and the court finds probable cause, and, you have a bond of $750. Does the state wish to be heard?
No, Judge.
All right, so sir, you have a bond of $750, okay?
Your Honor, I'd like to resolve this today if I can.
It's a felony charge. You cannot resolve a felony charge at first appearance, okay?
Thank you.
All right, James Young,
North Broward, Your Honor.
Mr. Young is before the court for one count of distributing or delivering heroin, and the court finds probable cause.
Judge, I'm going to be asking the court to consider pretrial release for Mr. Young. He's been a resident of Broward County in South Florida for all of his life. He does have a grandmother and family here. In fact, he has two grandmothers. He can stay with either one of them. So he does have a stable residence. He is not currently employed, unfortunately. So he does not have any savings with which to post a monetary bond. And as from what he advises me, his last contact with the criminal justice system was about 5 years ago.
Let's see. Let's make sure.
All right, state.
One moment, Your Honor. Yeah, it's definitely here. Michelle, could you just check to confirm something for me, please? You showing a March 10th, 2016 DOC release date? James Young. It's the same social. Same, yeah, height, weight, yeah. Yeah, Your Honor, I'm confident enough the information I have is accurate. Your Honor, Mr. Young was released from Florida State Prison most recently, March 10th of 2016. Out of Broward, he was convicted of three separate charges of burglary of a structure with damage over $1,000 and 2 separate grand thefts. He was sentenced concurrently on all counts, all charges, to 8 years in state prison. He's also previously been convicted of burglary of a structure, aggravated battery, sale, delivery of cocaine, and in 1992, attempted second-degree murder. He was sentenced to prison on all of those offenses.
All right. All right, based on these allegations, I am going to leave the $2,500 bond in place, okay? Suave Smith,
Go back yourself.
Mr. Smith is before the court for 1 count of grand theft,
So free. 2,500. Then you weren't paying no attention?
and the court finds probable cause.
There you go. That's your bond.
North Broward, please turn your mic off. Thank you. And Mr. Smith, the court finds probable cause, and I'll hear from the parties.
Thank you, Judge. In speaking with Mr. Smith, the $1,000 bond that's set is manageable for Mr. Smith. The only thing we ask of this court is if the court would enter a short order allowing him access to his belongings so that he's able to post the bond. He has it with him here in the jail.
Okay, I'll sign that order. State?
I'm not asking for any modification, Judge.
All right, so he's got a $1,000 bond. Good luck, sir. James Rainey,
North Broward again, Your Honor.
thank you. All right, Mr. Rainey. Mr. Rainey is before the court. Count 1 is grand theft auto. Counts 2 and 3 are felony violation of probation. Those, count 2 is, VOP is out of Duval County. Count 3 is a VOP out of Clay County. Those both have no bond holds attached to them. And the court finds probable cause for the grand theft auto, and your bond is $1,000 there, sir. Good luck.
See you
Tyrone,
Judge Pell.
I'm sorry?
I'll see you this afternoon.
All right, thank you.
You're welcome.
Tyrone Peterson. Okay. Mr. Peterson has 2 counts of distributing or delivering heroin. And the court finds probable cause.
Judge, in speaking with Mr. Peterson, I see that counts 1 and 2 have a $2,500 bond attached to both of them. Due to his financial situation, Judge, we are going to ask the court if the court would consider lowering each count to $1,000 each.
Your Honor, I have concerns about Mr. Peterson's future appearance in court. He currently has a warrant for his arrest out of Dade County on a pending theft. He was picked up late March of this year after failing to appear for a theft at his arraignment before Judge Lerner Wren. He had the theft resolved at first appearance. I'm also showing prior theft 2017, paraphernalia 2017, possession of cocaine 2016, grand theft 2011, possession of cocaine 2008, tampering with evidence 07, possession of cocaine 07. And I'm showing prior prior drug offenses out of the state of New York. Nothing further.
All right. So based on the nature of this arrest, this is through an undercover operation, then the details in the probable cause affidavit, I am going to leave the bonds at $2,500 on each count in place. Steven Syriacs.
He's sleeping in the back.
Mr. Syriacs?
Judge, he's advancing pro se.
Thank you. All right, Mr. Syriacs is before the court this morning on one count of petty theft. Count 2 is fleeing, attempting to elude law enforcement. Count 3 is operating a motor vehicle with license expired. Count 4 is disobeying a stop sign. And count 5 is a Department of Corrections hold that has a no bond hold attached to it. Okay?
Your Honor?
Yes.
I'm gonna ask for a bond increase on count 2, the fleeing and eluding. Reason being is it's particularly concerning, considering that he's got a hold for escaping, taking flight while in Department of Corrections custody. He was sentenced to a year and 5 months state prison out of Broward, November 30th of last year. I understand he's got a no bond hold on the Department of Corrections, but as he's shown that he is willing to take flight from that, from being in their custody. So I'm going to be requesting a $25,000 bond on 2, pretrial release of the GPS monitor, should he be eligible for release at some point during the pendency of this case.
All right, so Mr. Syriacs, you have a bond of $750 on count 1. On count 2, I'm going to impose a $10,000 bond with a level 2 GPS. And then counts 4 is not for magistrate, count 3 does not require a bond, and as I said before, you have a no bond hold from Department of Corrections, okay?
Thank you, Judge.
All right, John Seymour? Mr. Seymour is before the court for possession of cocaine, possession of cannabis 20 grams or less. Count 3 is a municipal ordinance violation. And the court finds probable cause.
Thank you, Judge. And speaking with Mr. Seymour, if the court was willing to keep count 1 at a $1,000 bond, that would be manageable for Mr. Seymour.
Okay. All right, I'll leave.
Yeah, I'm not asking for any
I'll leave the
modification.
bond in place. Fabian Watson. All right, Mr. Watson is before the court on one count of grand theft. And the court finds probable cause. I'll hear from the parties as to bond.
Thank you, Judge. In regards to count 1, I see there's a $1,000 bond. And speaking with Mr. Watson, unfortunately, that's going to be a little tough for him to post. Would the court consider a form of pretrial release in lieu of monetary bond?
I don't have an objection to pretrial, Judge.
All right, so Mr. Watson will be released to pretrial supervision. Sir, the attorney will give you the information for pretrial, for the pretrial office.
Just ask for an order of no return to this location, Your Honor, please.
I'm just waiting for when somebody's ready to listen. The jail will give you the information for the pretrial office. You'll be before, you need to report within 24 hours of your release. Failure to appear, failure to report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, sir, good luck.
Supervision for,
Jordan Tolbert,
you know.
all right, Mr. Tolbert is before the court for robbery by sudden snatching without a firearm.
It's like more like a theft to me.
Defendant is seen on surveillance video walking towards the victim's vehicle, which was a white Acura SUV. Victim exited the vehicle and showed the defendant's cell phone, which was in a sealed white box. Defendant then intentionally snatched the box.
Yeah,
Yes?
that's exactly what a
Yeah,
robbery by sudden
no.
snatching is.
All right, the court finds probable cause.
Your Honor, the state's going to be requesting a $7,500 bond and no victim contact. Mr. Tolbert is currently on juvenile probation for, among other charges, burglary of a dwelling, theft, burglary of a dwelling, theft. I also see on 2 occasions pickup orders were issued based on his failure to appear. Would also ask no victim contact.
All right,
Judge, in speaking with Mr. Tolbert, we'd have no objection to pretrial release. What would the court consider, due to his age, he's only 18 years of age, we all understand at that age none of us can make any money. He has been in Florida his entire life. He does not work at this time, unfortunately. Would the court consider more of a $2,000 bond with pretrial? He believes that's something he'd be able to manage through his family.
all right. At this time, I'm going to impose a $3,000 bond. And that's going to include a level 2 GPS monitor. And I'm ordering Mr. Tolbert no victim contact. If he's able to post his bond, he's gonna be on an ankle monitor as well as no victim contact. Do you understand that, sir?
Excuse me?
Do you understand what I just said?
No, I didn't hear you. It cut off.
$3,000 bond
Uh-huh.
plus a level 2 GPS, which is an ankle monitor, and no victim contact. Do you understand that? Okay.
Thank you, Judge.
Okay, Darius Wheeler?
Your Honor, I believe the next 3 cases are all going to be medical resets.
Yeah,
He's on loan.
so Darius Wheeler is on loan as well?
Yes, ma'am.
Oh, that's right, yeah.
There's no one left in the main jail.
All right,
And, I mean,
all right,
was
so
Sheila,
it
was
is
Rusnick taken off?
Darius Wheeler, Mohammed Abosnina. They're all med, yes. And Solomon Stinson. All right. Thank you, everyone. I'll see you this afternoon.
Thank you, Judge.